Good day. Now we have reached the fifth and last video of my discussions on the lessons of Module 3 in Institutional Corrections. Now I will be discussing the two topics, which is the Provincial Jail System and the Public Attorney's Office, or PAO. But before anything else, first is I needed to read my presentation before I gave my word of discussion. So now let's proceed. What is provincial jail system? So provincial jail system was the first established in 1910 under the American regime, supervised and controlled by the provincial government, headed by the provincial jail warden. So provincial jail system was established during the American regime, which is being controlled by the provincial government headed by provincial jail warden. Who supervised the provincial jail? Republic Act number 6975 provides that provincial jails shall be supervised and controlled by the provincial government within its jurisdiction. So, the provincial governments are the one who supervise the provincial jail system. So what is provincial prisoners? One who is sentenced to a prison term of 6 months and 1 day to 3 years. So these are the provincial prisoners. The vision of the provincial jail system is an institution managed by God-centered professionals and trained personnel to serve as the principal catalyst for rehabilitation, restoration that leads to reformation of the social, physical, and spiritual aspects of persons being detained to develop as laws-abiding citizens for eventual reintegration into the mainstream of society. Next is we have the mission. The office of the provincial warden shall promote safe and total detainment and rehabilitation, restoration of detainees under its custody. The goals and objectives of the provincial jail system. Office of the provincial warden is committed to carry out effective implementation of all programs, projects, and activities relating to jail detainment and rehabilitations of prisoners being sentenced, detained, or held for trial by the Court of Justice. Second, we have develop and attend to the welfare of detainees in the provincial jail by providing subsistence and other welfare benefits, and through provision of jail decongestion programs. Last is we have to provide protection services and prepare the inmates socially, physically, and mentally and spiritually to become productive citizens for their eventual reintegration into the mainstream of society upon pardon or release. Next is I will be discussing the Public Attorney's Office, or also known as PAO. So this is the logo of the Public Attorney's Office. Now, let's get to know what is Public Attorney's Office. So Public Attorney's Office, or PAO, is a attached agency of the Department of Justice which provides indigent litigants free legal assistance. Just like how I demonstrate or discuss this in my first video, which is PAO is one of the attached agency of the Department of Justice that gives service to the indigent people. The PAO shall be an independent and autonomous office but attached to the Department of Justice in accordance with Section 38, Chapter 7 of Book 4 of this Code for purpose of policy and program coordination. The POW shall be the principal law office of the government in exceeding free legal assistance to indigent persons in criminal, civil, labor, administrative, and other quasi-judicial cases. So the POW shall be the law office of the government which extends free legal assistance to those indigents, whether in criminal, civil, administrative, and other quasi-judicial cases. The POW gives free legal assistance for those indigents who cannot afford an attorney to be with them during the court trial or any other cases. Okay, here are the powers and functions of the POW. So the POW shall independently discharge its mandate to render free of charge legal representation, assistance, and counseling to indigent persons in criminal, civil, labor, administrative, and other quasi-judicial cases. So these are the powers and functions of POW, is to give legal counsel, assistance to those indigent persons without charges, because they are mandated to render and free of charge and legal representation. In the exigency of the service, the POW may be called upon by proper government authorities to render such service to other persons, subject to existing laws, rules, and regulations. So the vision of the Republic Attorney's Office, a government agency that is God-centered and dynamic bureaucracy that is responsive to the overgrowing legal needs of the indigent and oppressed, led by the highly competent, world-class, development-oriented, honest, dedicated, and nationalistic leaders and lawyers. Now we have the mission. The Public Attorney's Office exists to provide the indigent litigants, the oppressed, marginalized, and underprivileged members of the society free access to courts, judicials, and quasi-judicial agencies by rendering legal services, counseling, and assistance in consonance with the constitutional mandate that free access to courts shall be denied to any person by reason of poverty, in order to ensure the rule of law, truth, and social justice as components of the country's sustainable development. So, in short term, the Public Attorney's Office functions, powers, or its vision or mission. The one main point of POW is to help those indigent litigants, those poor people who cannot afford a lawyer. So the POW will do their job to give legal assistance services and counseling to those persons who are in need with their help. They need to render a free representations in order to help those individuals who need them during court trial or any cases that they are facing. So this is the main point of the Public Attorney's Office. So this ends my discussions in the Module 3 of Institutional Correction. Thank you so much for listening.